Everybody, this is Socio-Legal from Nepal. I'd like to share some leading cases on women's rights in Nepal, which are the landmark decision of Supreme Court of Nepal. In 1990, the establishment of democracy, the feminist movement come out and their voices raised towards women's legal rights. Onward of 1990s, the women activists are raising the voice regarding to gender equality, and mainly the cases concerning with the issue of inheritance property rights, right to privacy, then right to reproductive rights and right to identity, right to privacy and right to employment. In these issues, many cases that PIL cases are filed at the Supreme Court of Nepal. Afterward, the Supreme Court has given the interim order to the government to enact the gender equality laws regarding these issues. So these are the issues which is raised by the women activists in Nepal and filed the writ petition at the Supreme Court. Then Article 88 of the 1990s Constitution and the interim Constitution of Nepal, Article 107 of the are the vested the exclusive jurisdiction to the Supreme Court of Nepal. These are the main articles which has given the constitutional validity of laws in force in the territory of Nepal. And the issue order of the settlement of any constitutional or legal questions involved in any dispute of public interest, litigation or the concern. So that's why these are the key articles of the Constitution which has given the rights to the any citizen of Nepal, which has given the PIL rights to file the cases at the Supreme Court. These articles also given the unlimited grounds for the locus standi. So according to which any Nepali citizen can sue a writ petition in the Supreme Court challenging the legislative and administrative actions. So these are the grounds that are the inconsistent and contrary to the provision of the Constitution. Any citizen has the right to file the writ petition. It allows the judiciary to invalidate the laws which is considered inconsistent with the provision of the Constitution. As well as these are the power of judicial review or the judicial activism also definitely magnified the scope of the judicial activism. So the Constitution has defined the powers of the institution of executive and legislature. So in this regard, there are many cases regarding the gender issues, but I would like to add some leading cases, not every cases. So the Mira Dungyana versus FMG, Ministry of Law of Nepal, can be cited as a remarkable case in the history of Nepal, history of feminist movement also, because this one is the first case of regarding the gender issues, which is directly related to the inheritance right of the women. In this case, the petitioner had challenged number 16 of the chapter on partition of the property, which is in the country code, which have the provision of the law is that the sons the birthright to the share of the property, parental property, but whereas the daughter's right in the parental property was conditional. That is the discrimination regarding the right to equality. Supreme Court has declared that the provision was discriminatory to the extent. So that's why the right to property has a the birthright, whereas the son had the birthright, whereas of unmarried daughter, it is conditional upon completing the age of the 35. So that is the direct discrimination between son and daughter regarding the inheritance property rights. The court undermining the provision of the Article 11, 1, 11 and 23, 88 and 131 of the Constitution issued a directive order to the government to introduce an appropriate bill in the parliament. Afterward, we have in the Nepalese feminist movement have play a vital and significant role towards these issues, and the movement they lobby to the government, and the government prepare an appropriate bill and submit it to the parliament. This is the one of the great achievement of the feminist movement regarding the parental properties rights of the daughter. So long period of the submission of the bill at the parliament, that is the 6 years, this feminist movement comes success, and 11th Amendment Bill passed by the Parliament, which cover the property rights issues, which cover the marriage age of the marriage of the male and female are equal. But before that, there is a discrimination between the age of the marriage, as well as there are so many laws regarding the abortion right is not legalized at the country. But after 11th Amendment of the bill, there is the right regarding the abortion right. The abortion is legalized by the that is the amendment of the 11th Amendment of the country code. So this is the second time in the history of Nepal, 11th Amendment of the country code, which covered the women's inheritance rights, divorce, marriage, abortion, rape also. There is a before the 11th Amendment of the country code, there is no any provision regarding the gang rape cases. That law is not covered regarding that issues. But afterwards, then the rape law has the definition is also the wider, and so all the regarding the legal rights regarding the right to equality has maintained afterward of the 11th Amendment of the bill. This amendment is very significant, which cover many actors section of the sector of the women's legal rights. So we are proud of that. This is the first movement. And another issue is the right to privacy issue, which is the case is Annapurna Rana versus that this case is also one of the landmark decision of the Supreme Court. The petitioner has claimed that there is the violation of the right to privacy of her. So that's why she has filed the cases writ petition at the Supreme Court. So the Supreme Court also the court invalidated the virginity test order, relying on the grounds that the order violated constitutionally guaranteed right to privacy. So this is the one of the landmark decision which is done by the Supreme Court. And according to the judgment, even judicial authority cannot enable itself to substitute the fundamental rights of an individual by administering virginity test in the name of the collective illegitimacy. So this decision is one of the landmark decision of the Supreme Court. And in another case, that is Sharmila Parajuli, has also claimed that it is regarding to the Supreme Court issue the directive order on the government to enact a comprehensive legislation in order to ensure women's right to freedom from sexual harassment in the workplace and public places as well. Afterward, the court has given the directive order to enactment of the Sexual Harassment Act, but till date there is no any enactment regarding the sexual harassment laws. So that the directive order is there, but all the directive order is not implemented by the government. Another case that Meera Dhunana's case, that is the court issued a radical judgment that stand for women's right to self-determination in deciding whether or not to have sexual intercourse with the husband. So this is one of the very vital, interesting cases which is regarding to the marital rape. So the chapter on rape failed to rape of a wife committed by her husband using force, threat, fear, and duress, thereby provided penal compensation to the offenders. Petitioner also contended that such exemption was contrary to right to equal protection of law, irrespective of marital status protected under the CEDAW Convention. Afterward, this writ petition, the government has also changed or amended the laws regarding the marital rape. So now in Nepal, in the South Asian country, it is in Nepal, there is a legal provision regarding the marital rape. Afterward, this the interim order of the government, the court. In Reena Bajracharya case, here is the one of the case which is the which regarding to the equal right to the equal the service. So in this case, in the rule 61 and 3 of the service rules of the Royal Nepal Airlines, cooperation employees rules was challenged on the ground that the rules had fixed different periods of services, age of compulsory retirement to air steward and air hostess. So there is a discrimination between the air hostess and air steward regarding the retirement of the services. So the retirement of the services of the air hostess is age of 40, and the retirement of the steward is the reached 55. So this is the discrimination within the gender perspective. That's why the writ petitioner was challenged these sections. And the court has also addressed regarding the questions of the gender equality forcefully raised by the petitioner. A special bench held that although other provision of the service rules concerning provident fund, other benefits and leaves were similar in case of both the air hostesses and the stewards. The implement provision embodied in the Rule 16.1.3.1.3 appeared to be discriminatory and violative on the spirit of the 1990 Constitution. So afterwards, the judiciary has given the interim order to the government, and the section of the that